Good evening, this is John Milburn for LAWS11057, Introduction to Law, and this is week 12, term 3, 2018. Thank you very much. We have a good roll up this evening, and congratulations on making it this far. Okay, in terms of an analogy, I guess football, rugby league, the first 6 weeks you were up against your own try line. You were defending hard, everything was being thrown at you, and you kept the opposition out. Then at about the halfway mark, things started to turn, and now we're in that home stretch, and you're in the attacking zone, and you're ready to score. So be optimistic about going into the exam tomorrow. You've done a lot of hard work, so you deserve to be here, and you deserve to do well. Now, when we encourage you to review for the examination, we ask you to take a global approach. So what that means is review all of the material that we've covered in this unit. And I know that's a lot. And you'd be saying, oh, can't we have something more specific than that? We'll provide a few more details as we go. And I'm looking at the chat facility for the take-home paper. As I recall, I'm releasing it tomorrow, that is Tuesday evening at 6:30 p.m. And your task is to complete and upload the work by Wednesday evening, 11:45 p.m. Now, this is a little different to a normal assessment during term because this is the replacement for the invigilated examination. And what that means is that the timeframes are strict. So I would not leave it till the last minute to upload the paper because the system might lock you out. So do give yourself a little bit of lead time just to make sure that doesn't happen. So in the scenario that you'll see tomorrow, you can expect that there'll be some statement to say in the scenario itself, make sure you upload by 11:45 p.m. It's worth nothing to me if it's not there at that time. I'm going to ask a little quiz now. And this is just to get you thinking about the take-home paper, thinking about the work that you've completed in this unit. There's no right or wrong answer here. I'm really looking for your thoughts. In a word or two, or maybe a phrase, can you identify for me some of the key issues that you think we've dealt with during this term? So what are some of the words or maybe a phrase that deal with the key issues? In other words, this is leading into what you might expect in the take-home paper. All right, what words come to mind? Ethics and professional practice, or like that. Importance of ethics, yes. Legislation and rules, yes. Ethical issues, common law, equity. Yep, I like all this. Legislation and ethics. There's some good answers here. Research, yes. Barristers and solicitors' rules, yes. And coming back to practice and some of the rules. All right, so some good answers there. What about communication? I didn't see that word. That's a pretty important one, isn't it? So it's always difficult to examine someone in terms of oral communication. It's a little easier to examine you in terms of written communication, if you like, as a practical exercise. And I guess the only way to deal with the issue of oral presentation is to ask you to describe or perhaps put a scenario where you might put up some words. So I think you're on the right track in terms of the sort of things that you might expect. Now, Gareth correctly identified legal research. So tell me, not just you, Gareth, but anyone, why is research important when studying law? I know that sounds probably a really basic question, but think in terms of outcomes, yes. Why am I drilling research into you? Identify the law that applies, yes. Facts, says Tim. Precedent, yes, precedent's very important because the law is always changing, yes, Peter, and the basis of the outcome, evidence-based. So these are all important things. In Introduction to Law, in the first week, and correct me if I'm wrong, I think I indicated to you something to the effect that you don't have to learn all of the law. Gareth says statutes are the primary source of law. Well, one of the primary sources, case law, is also a primary source of law. Secondary sources are everything else, textbooks, etc. What I'm telling you now is a secondary source of law. So you can't remember everything, says Tanya. Yes, that was the point that I was making. So there's no lawyer that knows all the law, not even close. There are some lawyers that have a very advanced knowledge of certain parts of the law, but it's just impossible. You can't know it all. So what that means is that it's important that you think like a lawyer, research like a lawyer, and communicate like a lawyer. If I had to describe what I'm trying to do in terms of teaching students in Introduction to Law, I think that's probably it. And add to that, acting in an ethical manner while practicing lawyer as a lawyer. So they're the 4 key issues. Now, put yourself in my shoes, having to write an examination, testing you in those key areas. What do you think I would do in terms of how would I test you for your legal research? Any ideas? What would you do if you had to test students in terms of legal research? Finding legislation, yes. So a good theme coming through there, that we look to statutes. And the reason that's important is that many people go to textbooks first, whereas I'm encouraging you to go to the primary sources. Finding legislation, get to find a particular title, yes, as in a case or piece of legislation or something else. I'm looking at it from a different perspective. Like previous exams, identify when rules are used to influence outcomes. Yes, Tanya says how law is made. Yes. What you might expect from me is, and Tim's, this is getting close, classification of law, says Tim, and analysing a previous judgment order, says Sky. These are all good things. Coming from a practice background, it may not surprise you that one of the things that goes through my mind is solving a legal issue. Now, when it comes to solving a legal issue, you invariably won't know the answer before you start. And that's the whole idea of legal research, isn't it? If you knew the answer, you wouldn't have to research it. You may go and double check the answer, but the idea of the legal research is to try to find the answer to a legal problem. Now, how do you go about finding an answer to a legal problem? What are some of the important steps that you need to consider? We've had some good answers towards this already. What are the first things that come to mind? So Lachlan says go to Barnett Jade, yes. In other words, go to a reliable, reputable platform. Sky says have a look at case law of similar manners. Yes, I agree with that. But even more basic than that. Even more basic. Yes, Tuna, yes, identify the issues. Identify the problem. Now, if I'm examining you in terms of your research skills in Introduction to Law, I've got a basic problems, haven't I? Rachel says use the steps of IRAC methodology. Yes. You can see the basic problem I've got when it comes to testing you in your research skills in Introduction to Law. Can anyone identify what that basic problem is that I've got? You see, what I'm encouraging you to do here is I'm asking you to look at the end result and work back, which is, I think, something I encourage you to do in first one. Tanya says it's a very broad base. Introduction to Law is really broad. We cover so much material. But if I'm teaching you, if I'm asking you to research If I'm trying to test your research skills, the basic problem that I've got, Nicole says not everyone uses the same resources, and that's fine. Yes, I agree with that. And in practice, we all use different resources. People say, oh, I like Westlaw, I like LexisNexis, I like Jade. So we all have different ways of doing things. The basic problem as I see it is, and this is meant to be respectful, don't take this the wrong way, but you don't know a lot yet about substantive law. So if I'm going to teach you, if I'm going to ask you to do a research problem, inherently, I'm asking you to research something that you have from this course, university degree, you have no prior knowledge yet. If I ask you to research something on consumer law, employment law, criminal law, civil law, discrimination law, so commercial dispute law, leasing law, property, you'll say, it doesn't matter what family law, whatever I choose, you'll say, we haven't studied that yet. And that's the whole point. So if I get you to do a legal research task, the first thing you'll note is this feeling of, I don't know anything about this area of law. And my response, again, sympathetically, is, yeah, I know that. And that's the point of legal research, to find the answer. So what is common in any area of practice, whether it's administrative law or contract law, it might be a torts law question, is that you need to identify, and Rachel got it, you need to go through the IRAC methodology and think about what are the key issues here, what are the material facts. I kind of like the MIRAC method. What are the key facts? What are the key issues? Where do I find the law? So all the legal research work that we did, all of those websites where you've got some idea of where to start looking, will now come into play. So hopefully by now you've developed your favourites, you've got your methodology. And of course, what we did in the second assessment with your toolkit is for you to build something personalised that works for you, that will help you to get to the answer that we ultimately want in an area of practice that you haven't studied. It's all good fun, isn't it? It's the only, I reckon this is the only time that an examiner can genuinely say, I'm examining you on an area of practice that we haven't considered. But you'll have fun, all right? I'm grooming you to this. Grooming's a terrible word. You don't say that in law. What I'm saying is, what I'm saying is, make sure that you expect to be overwhelmed initially when you look at the paper and say, I've got no idea. Then remember the quote from week 1. Was it the first thing that I said? Acting like a lawyer means keeping a cool head when all around you are losing, their focus, or something along those lines. Sky says, can we please make it property law? I wrote the paper ages ago, Sky. I can't change it now. Mind you, that said, it could be property law. That's one of my favourites. So be prepared to be overwhelmed when you first look at the paper. Go to your toolkit, go through the methodology, and then work through the problem. All good? All right. So, legal research, thinking like a lawyer, IRAC methodology, legal reasoning comes into it. Ethics is always there. On any answer to any legal question, always think about the ethics side of things. There may not be anything relevant, but you've always got to consider it. And then, finally, communication. So, communication, what are some of the key issues? Well, communicate like a lawyer. You've got a good idea of the way in which I want you to present your work. Generally, in the active voice, not the passive voice. I think you all know what that distinction is now. If in doubt, use short sentences, but there's nothing wrong with longer sentences. And sometimes I think the flow works really well when you interpose longer ones with some short ones. Really good for impact. But if in doubt, the general rule is short sentences. Where I see people writing particularly badly, it's where they have gone on to ramble and a thought becomes 2 or 3 thoughts and 4 thoughts without actually stopping for a full stop anywhere along the line. Make sure that you reference your work by footnote referencing in the AGLC. Now, why do I like take-home papers rather than invigilated examinations? Well, in Introduction to Law, from what I've told you, almost everything that I've described as what I want to test you upon, I couldn't do it in an invigilated examination. I couldn't give you a constitutional law question with no access to the internet and research facilities. That just wouldn't work. So in an invigilated examination, it would tend to be fairly dry. Okay, any questions about what I've said so far? Is anyone developing a cold sweat and worried, or are we all good? You're all doing fine. Okay, that's good. When it comes to the take-home paper, you need to consider some of the areas that we've covered in The New Lawyer. I'd like to take the opportunity just to, Nicole's got a good question. What areas of the exam do students tend to mess up in? Timing. Like in an invigilated examination, it amazes me that people just don't manage their time well. That shouldn't be a problem. You've got 29 hours, which should be way more than you need. And of course, some of you are working, have other commitments. In fact, most of you would. So very rare that anyone has all the time to go with it. I'm not sure I can really say. That's a really good question, Nicole. Where do students tend to mess up? Probably sometimes maybe I think people panic. So you don't want to do that. Sorry, I can't give a good answer to that. I'll think about one tonight probably. Okay, if you've got your textbook handy, if you're watching this as a recorded session, dig out your textbook. I just want to bring your attention to a few things. These are not specific these are not specific exam hints, but just some reflections on some of the more important areas that we've covered. Page 14 deals with work sectors. So even though I've tailored the unit generally towards those that might practice in the law, I'm extremely well aware that many of you, in fact, the great majority of you, won't actually practice in law. But I don't apologise for the way in which I present the unit, because the idea is that we're doing Introduction to Law. That's what lawyers do. And even if you're not practicing as a lawyer, the idea is that you understand better the way that lawyers go about their task. So work sectors give you just an idea of what can be done. Have a look at page 26. It deals with the priestly 11. And that's something that I would encourage you to consider now leading into the exam, because it gives you a kind of a broad approach to where the examination legal research question might come from. And I guess I'm not giving too much away from what I've already said, that there'll be a legal research problem. So that'll point you to some degree in the right direction, perhaps. Then when you're thinking about how to go about your work, have a look at, in the take-home paper, have a look at figure 1.4 on page 27, which are the threshold learning outcomes for law. So again, you can understand that in setting the paper, I'm trying to test you in relation to these things. And that's why I've said that it's not just knowledge. I'm not all that interested in what you actually know now. That's important. But I'm interested in your thinking skills, which is what we've discussed tonight, your research skills, your communication skills, and your acknowledgement of ethics and professional responsibility. So you can see that all of those things that I've talked about as important in the examination come from the threshold learning outcomes that I'm required to teach and that you're hopefully learning. So the take-home paper generally requires you to think of TLO 1, 2, 3, 4, 5, communication in a written form, and to some degree, 6. Now, page 29 deals with the issue of learning effectively, and you'll see the quote, which in part says, "We should concentrate on learning on what the learner does and by the way the learner thinks he or she is doing it, rather than what the teacher does." So I'm teaching you in a way where you are the learner rather than necessarily adopting my practices. And that's why I was very keen for you to adopt a toolkit that works for you. So this is the flipped classroom model, where we're looking at things that from your perspective rather than from the teacher's perspective. Page 47 deals with categories of law. And again, this is very important because when you answer a problem, you need to consider both the substantive law and the procedural law to some degree. In other words, it may be that there is an element of civil or criminal procedure inherent in the question that you need to answer for the take-home paper. In other words, you need to have an idea of which court, which jurisdiction, which judges or members have jurisdiction to do what. If you look over the page, you'll see public and private law and the distinction there. And again, different categories of law and the broad category of civil and criminal, and other categories, domestic and international. If you look at the purposes of law on page 52, and you'll see that from a broader perspective, there are different scenarios. So in the take-home paper, you may have a scenario where your task is to assist parties in resolving a dispute. It may be to maintain social order. Your task may be to assist in reinforcing community values, prevent the misuse of power. So law is meant to be certain, but also flexible and accessible. So what we're trying to do in this is get you thinking broadly at the start and then drill down from there. And at the same time, think about your end objective and work backwards. So it's multifaceted. Now, I'm skipping to page 99. That's not because what's in between is not important. It's just that I'm not bringing it to your attention right now. On page 99, we have the difference between common law and equity. So, are you pursuing a common law remedy or an equitable remedy? Are you pursuing a criminal law action or a civil action? And just because parties are married, does that mean that all litigation between them must, for example, proceed in the family court? Page 127 deals with state and federal relations. So understanding how these two work together, the respective constitutions of federal and states are important. The issue of exclusive powers, concurrent powers, residual powers, which is constitutional law, and Section 52, for example, of the Constitution, which confers upon states specific power, or the Commonwealth's specific power rather, is important. Page 127 deals with those issues. So have a look at that and understand these exclusive powers and the concurrent powers. So it's a really good reckoner there. If we go to page 152, you'll see that we're discussing sources of the law. And we now know, of course, that the primary sources are statutes and case law. Statutes is also known as legislation, also known as acts. But don't forget regulations. the delegated powers, which are still primary sources. So, is your client, for example, pursuing a remedy under legislation or common law? Is your client seeking a remedy under state or federal legislation? Does your client rely to some degree on delegated legislation, regulations? Now, page 170 sets out the federal system and then goes on to describe the state systems in general terms. So that's the appellant system and the hierarchy, if you like. And in the state systems, there are some basic flowcharts there in terms of, and then there's some reference to specialised courts. Just remember, of course, on page 179 where it talks about the financial limits, say for QCAT 25,000, if you look at the top, that's only in relation to small claims, which is, as you know, only part of the QCAT jurisdiction. Most of it is not part of that division, if you like. All right. Question, John, can we use material and reproduce answers sourced from our graded assessment and exam toolkit, references, etc.? Well, that's a very good question. Absolutely, yes. That toolkit is yours. Use it as you see fit, and you can absolutely use that. Anything that you've created is absolutely fair game. I hope that answers your question, Tim. So that's the state and federal jurisdiction. Have a look at page 182, and we deal with civil and criminal procedure. So that just gives you an idea of how these things start and continue. We haven't done a lot of that during term, but it's still important from a practical perspective. These are the things that clients expect you to know, and you work through the system. So having some idea of how you commence proceedings is important, then how you control the proceedings, likewise, and are there preliminary matters that oblige you to consider action in a certain way. So before you sue, in some jurisdictions you need to obtain a certificate to say that you've attempted to resolve matters outside of litigation, for example. Now, page 200 deals with the commencement of a huge area, legal research skills. The important thing really at this stage is that you brush up on your systematic approach to legal research, whatever it is that works for you. And whilst there is a figure on page 203, it's not necessarily something that you have to adopt. But if you're stuck, it's a good place to start. Have a look at the table on page 206, which provides, if you like, step-by-step planning your research, questions that you might ask. If you're stuck in your take-home paper, that might be an area that you could consider and access. Another useful approach, and one that cropped up a few times in the toolkits, is the Statsky's cartwheel. You'll see that in figure 6.2 on page 209. And that provides an example in relation to the term wedding, how you might think about the broader aspects. And on page 210, you'll see the table there where the cartwheel, as described, is used in a practical sense and how things can grow from there. The flowchart on page 212 is also useful because it describes the primary sources, legislation and case law, and the secondary sources, everything else. If you are referring to, say, now what was it, Sky, you wanted property. So if you were referring to the Property Law Act 1974 and you're referring to section 100, this is not necessarily an exam hint, but if you were, then I would expect that that would be the reference in your paper and not a reference to the textbook where you first read it. So you understand the distinction there? If you're referring to section 100 of the Property Law Act, 1974 Queensland, that's the citation. Don't give me the citation of the textbook that describes what's meant by that section. So always the primary source rather than the secondary source. Then, so legal research, huge area. I won't say any more than that. Interpretation skills, we haven't done a lot of it in this unit. Can anyone give me some idea as to why you think we haven't done a lot of work in interpretation skills? It's a very practical answer, this. And this is kind of an exam hint. And the answer is that we have a separate unit completely. So a standalone unit, that's it. So I know I'm taking that as well. So many of you are doing that also. So you can expect that the statutory interpretation specific questions will be in that unit rather than this one. But still, it's still important and you must be aware of it and be ready to apply it for this examination. Now, Chapter 8 deals with thinking skills. This provides an overview of the sort of things that you need to consider. Legal logic, the broader use of your skills, the IRAC method, very important, and legal logic in terms of things like faulty reasoning are always important as well. And then finally, communication and redrafting. We did a redrafting exercise a few weeks ago, didn't we? Where I gave you some gobbledygook and you had to redraft it. So what's the point of that? What's the point of me going through that exercise with you? Clear communication, yeah. Thanks, Nicole. To learn to write concisely, yes, absolutely. Thank you, Rachel.
Just simplify the whole statement.
Yes, that's right, exactly. So ascertain the important facts as well. So that's the idea, to extract that which is important, distill the information and present it in a form that is easy to read and plain English drafting. All right, if you haven't looked at my Level 3 examination or short window online paper preparation video, please do so. I suspect that you've all looked at that and you'll get an idea of what you might wish to do tomorrow if you've got time in preparing for the examination beyond what we've discussed so far. Any questions before I continue? And I haven't got much more to go. All right, all good? Okay, so with the take-home paper, don't forget where you're presenting a legal research issue, if that is on there, make sure that you state a conclusion, argue in favour of it. It doesn't matter if your conclusion is different to mine, but I do want to see a conclusion. I'd like to see you justify a conclusion. Remember, on the High Court, you might have 4-3 decision. So there's nothing wrong with making a call that happens to be different to what I would say as the answer. Okay. Remember, of course, critical evaluation requires you to consider what's there and weigh up arguments for and against. All right, I think that's just about it. So are we all good? Any questions? Fine? All right. Well, thank you very much for, you've been a really good cohort. And remember, you can collaborate to some degree in relation to the take-home paper, but do it cautiously. You're not directly able to give each other material that you use, but you can talk in general terms, I guess is a fair way to say it. Okay, well, if there's no other questions, thank you very much for participating. This is the end of the unit. If you haven't done some feedback, please do so, and keep in touch with each other. I'm sure that you'll be able to help each other beyond this unit. All the best, and good luck tomorrow.
Thanks, John.
Thanks, Tuna. All the best then. Bye.
Bye.